everyone, welcome. I'm Douglas Kellner, your co-chair, and to my right is Peter Kasinsky, also co-chair, and to his right is Commissioner Greg Peterson, and then we're joined by video with Commissioner Spano. So we'll start with approval of the minutes. We'll take the regular minutes first. Is there a motion to approve the minutes as drafted?
So moved.
Those in favor say aye.
Aye.
Aye. Then those minutes are approved. We have the minutes of the executive session. There has been a revision. Commissioner Spano, have they gone over the revision with you?
Yes, they have. I received them and went over them.
Okay.
I'm fine with it.
All
I
right.
move that we adopt them.
Is there a second?
Second motion.
All right. Those in favor of adopting the minutes of the executive session as revised, say aye.
Aye.
Opposed? All right. So they're adopted unanimously. We'll then turn to the unit updates. We'll start with our co-executive directors, Robert Brehm and Todd Valentine.
I think there are a number of items that we've worked on to prepare for today's session, but I think one of the biggest items that I wanted to speak to you about today, following up on our last meeting, is the budget. The picture still remains where the agency is approximately $1.7 million behind what's needed for personal services, and we are about $1.4 million behind what we need for contractual services, so it's a little over $3 million deficit just to maintain services
And what's the whole
before
budget?
chapter.
Bob, what's the entire budget?
I have that number here. I will get you. Well, I have a packet if you want. The entire appropriation includes just under $3 million for contractual and $4 million for personal services. The only other money on top of that are the grants that we received for the federal Help America Vote Act, which was $19.4 million, and the state cybersecurity money, which is $5 million.
So you're saying the budget for the agency is about $7 million?
Correct.
And-
Not counting enforcement. That's
Okay.
about $1.5 million.
Okay, and out of that 7, you're saying we're short 3?
Correct. Well, we have 7. We need
3 more.
So you're 30% short of what you
it's
think
above
we need.
30%.
Got it. That's all. I was just trying to figure out what the percentage was.
So we have communicated in a meeting that Co-Director Valentine and I and staff had with Division of Budget. We now have a Deputy Secretary, Jonathan Smith. I had a preliminary conversation with him, and Todd and I have a call with him on Thursday to go over these items. We've communicated in writing in the 30-day amendment period that there's an issue, and Todd and I testified before the Joint Legislative Committee on the Budget on these issues, that we're in this predicament. We're also at the next stage, because there were no additional funds in the 30-day amendment to solve this problem, to evaluate what would we need to do as an agency to meet a reduction of this size. We don't really have an answer for you yet. We're evaluating that. We hope we'll have that at your March 19th meeting. But it's significant. If you look at the services we're providing at a time when we're being asked to do even more for early voting, electronic poll books, and the other reforms that are coming our way, this number does not reflect the added responsibility of those programs. So it would be nearly impossible to deliver on those new programs because we would have to take so drastic a reduction, and it would hit across the agency from a campaign finance compliance, from election operations and oversight of boards of elections and the guidance that we normally would be able to give. Also, while we're trying to develop new guidance and new programs. So it would be a significant impact on the services that we would need to do to provide that oversight. It would also be a significant impact on the technology upgrades that we're currently working on for the candidate management, the campaign finance, and many others that are just trying to keep the systems up to date. So it would be a significant impact, and we just wanted you to know that. We're continuing to focus on it, but I think our next step is, in order to give proper notice, we would have to look at how we would reduce staffing and contractual services to meet the what we anticipate is the available money. That would be a big change to what specific programs would be impacted, and we hope to have that plan for you at the March 19th meeting. It's not a pretty picture. We're also working to hope we don't have to get to this stage of planning, so I think we have to do it to be prepared.
That's pretty severe.
It's over 30, it's over a third of staff, and it's almost all of, it's more than all of the contractual. So we pay a little under $1 million for the contractual services now, but we have a $1.4 million deficit in that fund. So even if we stopped all the contractual people, we still have to make up $400,000 in that department alone. And they support the agency because we have not succeeded in getting approval to bring on staff to do the work that the IT and technology people are working on. So we hope to continue to make the case. I can only be hopeful. But I think we have to do our due diligence to plan.
Yeah, I agree.
Anything else?
No, that's the biggest project right now.
All right, well then, let's go to the report from the councils, Kim Galvin and Brian Quayle.
Thank you, Commissioner. The last meeting, the commissioners approved amending Part 6214 with respect to contribution limits. The council's office prepared and filed that paperwork on January 29th, and the change was published rather on February 13th. And that was an emergency rulemaking, and we'll come back to a final adoption on that after a 60-day period after publication. The unit worked on the matters that are in the packet with respect to the proposed transfer regulations. The petitioning for the June primary has begun, so ballot access, questions and calls, as well as inquiries from boards of elections and the public regarding signature calculations have taken a considerable amount of time and energy from both the council's unit and operations. Brendan Lavulo and I had the privilege of participating in a meeting of village clerks in Herkimer County, which is not very far from here, where the board, recognizing that there were consistency issues in how certain issues were handled, brought their fellow election administrators together to harmonize practices and procedures and to discuss best practices. And we were privileged to participate in that, and I think made a significant contribution to the process, and it's something that I would recommend other boards take such an affirmative act to do. The compliance unit is finalizing preparation of the fourth quarter deficiency list, about 85 deficiencies recognized on the preliminary list. The training unit has been very busy, updating EFS user guides and other materials and working on relevant documents for the anticipated rollout of the new Capus Vitus system. Due to the LLC law, which went into effect shortly after the last board meeting on the 31st, the board posted a notice to filers, LLCs, and obviously those receiving LLC contributions about the new limits. Shortly thereafter, we issued detailed guidance for treasurers on precisely how to use the current filing system in order to report LLC attributions, and that was turned around very quickly and efficiently. And both those notices are presently on the website. The unit obviously remains very...
Brian, can I ask a question about that?
Sure.
The LLC provision.
Absolutely.
So that went into effect immediately upon
7 days.
7 days after...
7 days
the
after
adoption.
signature,
Yep.
which was
The-
31st of January?
Went into effect, yes.
So if I made a contribution back in December as an LLC, how are they being treated?
A contribution in December was before the effective date of the law, so to my $5,000 limit would not apply. The aggregate $5,000 limit would not apply retroactively.
So we aren't applying it retroactively. So anybody up through January 31st would still get the same treatment they received prior to the change in law, and then anything after the 31st would have to be
Yes.
treated the new way,
Yes,
which is basically attributable to the individual.
yes.
Okay. All right, fair enough.
And so obviously the unit remains active in in a number of cases. There have not been significant developments in most of the cases since the last meeting, save one. The Eason matter is now officially off of our list of cases, and we're in the mode of the settlement agreement in that case completely. There's no more court proceedings in that case, so it's nice when a case comes off the list. Certainly, if there are any questions about any of the other cases or any details, we'd be happy to provide those. And then in terms of the compliance unit, its work, the January periodic for 2019 has 2,823 non-filers identified. That's up from the 2,531 in January of 2018. And if anyone desires detailed numbers on the number outstanding for any particular filing, certainly happy to provide that. The total number of reports reviewed by the unit today is 120,000, received 120,653, and they've completed reviews on 109,389, which means that we are keeping pace pretty well with the number in and out in terms of the workflow.
I'll just add that we did had a demonstration from IT on the new Campus FIDUS user interface, and it was excellent, and a couple of minor points that people made, but I think moving forward it looks very good. So and we just had that last week, and it really came along.
We're going to see something
Thank you.
next month,
Well,
hopefully.
hopefully, we're trying to do that one down.
That'd be good.
All right, we'll turn to election operations. Tom Connolly of Louisville.
Thank you, Commissioner. With regard to elections, we did certify Supreme Court vacancies that are going to be filled at the November election. We distributed that to the different counties. From a voting machine standpoint, we have ES&S application for their Express Vote XL, both as a tabulator and also a ballot marking device. We're still waiting for them to finish getting their source code to our testing lab, SLI. Once that's done, then SLI can do their work and they would provide their review to us. We're also waiting for some updated language on their TDP, or their technical data package. We did have two de minimis reviews of SLI on engineering change orders by ES&S. One of them was just a replacement printer for one that was end of life for the DS450 central count, and the other one was for the DS200 scanners, the application of texture-free surfaces around the outer housing for better adherence of seals. Dominion, we've been reviewing, when we had certified the ICE machine that was in the configuration where it was only using the primary monitor. They had submitted a modification for us to certify the system using a secondary monitor, which is only used for accessible voting sessions. We'll be probably finalizing that and bringing that to you in the near future. And then with regard to Clear Ballot, we're just continuing to work on a few more test cases, both the development and execution of them for their upgrade submission. On the cybersecurity front, as usual, we've been continuing to participate in our calls on cybersecurity, both our plans, risk assessments with our partners, Grant Thornton, OGS on procurements, and NYSTech. We've been reviewing our security incident response procedures and policies with NYSBOE for changes and updating. Since the early voting bill had passed, the staff has been reviewing security policies and procedures from other states to kind of just glean some insight into people who've already executed this before, to kind of prepare our own guidance for boards from both physical security and also from using the machines in early voting itself. We did meet, Brennan and I, with Jeff Baez, our CISO, met with the Center for Technology and Government. We've been working with them on some pilot projects, and so we had gone over to give them kind of a good overview of all the different election phases and the different processes involved. Todd and I had gone down to D.C. at the beginning of February for the National Association of State Election Directors Conference. That was a multi-day conference that had a lot of good presentations. And there certainly was a lot of focus on cybersecurity, but there are other topics covered as well. I was also, out of that, we met with Anthony Stevens, who's an Assistant Secretary of State from New Hampshire. He had invited us to visit New Hampshire while they were doing a machine demo with some of their local election administrators. I was able to attend that meeting in New Hampshire, which was a nice drive, a little bit far, but still good. And so there was some good conversation with some of the locals. They obviously do things slightly different in New Hampshire, and they use different equipment, but it was a good conversation to have. And otherwise, we continue to process our shoebox contract extension docs, and we've been working with IT on the development of the CAPA system. Brendan, did you have anything?
I'm good.
At the last meeting, we talked about the need to at least have an outline of how we would provide for certification of electronic poll books. Have you discussed that?
We have been yes, we've been discussing that. We've been having some conversations with NYSBOE, obviously, as our kind of security expert that we work with. We have been doing research on what other states have put into their certification or review process for electronic poll books. And we will be continuing to do so. As far as, should that bill pass, we would then be required to, with at least the current language, to draft minimum security guidelines for the devices and those networks.
And, where do we stand on providing guidance to the counties on early voting?
We've been working on it. We're looking to have a draft of Bob and Todd at the end of this week, and we imagine that we'll probably have some more internal conversation about that over the coming week or two.
Our hope was to have that internally at the end of this week so we can prepare for your March 19th meeting with something that you can look at.
Well, what are the key issues that you're going to be addressing in that guidance?
Well, I think we're going to be looking to cover not only the general physical security, as far as having voting and machines possibly out in locations for multiple days at a time. We're looking at how these machines can operate with regard to removing sticks or compact flashcards, portable media devices. We're looking at capacity issues. There are some machines that can only, like the Dominion machine, can only handle 2,500 ballot images on a set of cards. So there would definitely need to be multiple sets of cards. So we're going to have to figure out policies and procedures for keeping them secure. We're going to have to figure out how do we close all of those sets in a way that makes the most sense for the county boards. We're having a meeting with some of the local ES&S counties next week to kind of talk about the ES&S machines and how, any questions that they may have as far as using them in early voting. And we've also been discussing Dominion machines with Monroe County, who's been looking at doing some kind of just testing on different considerations that they may have to take into think about for early voting as well.
Now, the counties have to have a plan to us by the 1st of May. Is that correct?
Yes.
And will the plan include their anticipated process for early voting?
It's supposed to include their sites and I think the general outline of their process for early voting.
Okay. So are we providing guidance to them prior to that so they can use that guidance to help formulate their own
Right,
plan?
yes.
So what's our time frame then for getting guidance, official guidance to the boards so they can use the guidance for their May 1st plan?
So would I guess, bring it before the commissioners for the next March meeting, and then if that's all good, it would go out to the counties?
So you would bring a formal proposal we would actually vote on at the next meeting that we would
I'm not sure if
send
there's
out?
regulations in there, but certainly our goal is to get the plan drafted by the end of this week. Certainly we share that as soon as we've had a chance to review it and then get some comments. But our hope was not later than your March meeting, either get your feedback before then or at that meeting. There's no reason to hold it up if it's acceptable to people. I don't think you have to vote on it.
Okay.
If there's regulation changes that are coming our way, that we would have to bring to you. But we're still looking at how to deal with the security, the normal bipartisan processing of opening and closing 8 days in a row to make sure that we're all consistent with what the statute provides, where there are slight deviations. And the other guidance is certainly for the security.
Now, do we
the
approve
security of
these
balance.
plans that they submit to us on May 1st? Is this
They have
an
to pick their
approval?
sites by May.
They have to choose first.
Okay.
They have to, the plan that you're referring to is the plan to prevent duplicate voting under the statute.
Okay.
That does not have a date attached to it. Now, but that is also part of what we're talking about, when we're discussing either incorporating the electronic poll books, which allows you to do it in a different way versus if you don't have them. We're assuming you're going to have them, but right now we don't. So they have to have a process to ensure that voters don't vote twice within their own county, but in the event that they get information based upon the statewide transfers, which is going to go into effect at the end of March, so it'll be in effect for not only the June primary, but also for the November early voting, the process where a voter moves, and what is your ability to ensure or notify the old county that they've moved, you voted in my new district. Well, by the way, I'm going to tell you this, and if they haven't voted, you should adjust your poll book or list accordingly.
So we have to approve the process for avoiding duplicate voting.
And that's why we want to give them a template, so because there's only so many ways you can really do it based upon the technology and the process you have. If you don't have electronic poll books, then you have a hard copy list, so you have to figure out, okay, how do I make sure that if the county gets divided up and there's only one list, then it's not really a problem because you can only go to one spot to vote. It's in those situations where a voter can vote in multiple sites within a county that they have to then coordinate how they transfer that information. So it's really a limited number of ways that it can be done. The electronic poll books do make it easier. That has its own security provisions, which is why we need to incorporate that when you're transmitting data electronically, that you ensure that it's accurate and it gets there, it's not corrupted in the transmission. So that's why we're looking to what other states already do this. We're not reinventing the wheel. So we've been researching and right now have an amalgam of what the other states have done. And certainly they've done it well before electronic poll books existed. So if we have to go down that path, there is a model that we can use that Texas had done for many years before electronic poll books existed. But we have to plan for both because the time frame for implementing the poll books is short.
So do we anticipate this to be a county-by-county analysis, or is there going to be a statewide process for avoiding duplicate voting, or could different counties have different processes in
I
place?
think you'd have to accommodate how each county is going to staff and conduct early voting. Because some of the smaller counties probably have the ability, and they've expressed in some of the conversations while they're thinking of how to comply with the procedures, if they only have 20 election districts, Hamilton County has 11 election districts, they're going to have one early voting site at the county seat. So it's feasible that they could have 11 poll books and then just get that poll book to the 11 sites by Tuesday morning, open up polls. So it depends on where you are, and I think we're going to have to accommodate that there are going to be particular ways of of providing this service, all the way up to New York City, which would have a bigger issue of how they could comply. If we get if under our time frame, I'm not sure we will have e-poll book legislation signed if we're aiming for the middle of March at the rate we're going. So we can, it would be, so we're anticipating the version of the bill that we've seen. I don't have the number at the top of my head. I think it's Senate 508 and Assembly 2070, both in an A version. But
We do have the numbers.
I always check them. And the A version is significantly different, and we're going to talk, we have a county call tomorrow with all the county boards for our monthly call. This is on the topic because the biggest amendment to that law is that it would become effective immediately. The current version, the previous version was effective next year. So one, should it pass, it's effective immediately. Process by the state board, and counties can only purchase off an approved list. So that is different than the earlier version. So we are working at the staff level with that document. If it changes, we'll have to adjust, but that's the one we're using to at least come up with some planning around it. So we're hoping to say to the counties, if it is not available, here's the non-e-poll book guidance, and if it is, here's, based on everything we're reading in this bill, that you should consider if it gets adopted and you can use it in time. And that's harder to do because it won't.
So there's no time frame then for the counties or us to adopt a duplicate voting process in the state?
I see in the statute they have to give us a plan. I don't necessarily see us approving the plan.
Gotcha.
I don't see an approval process of a plan, but I think if we're asking, if the legislation is asking for the county to give us a plan, the way we know it's a good plan is to give them guidance and to make sure we give them, almost like we did with the security plan, here are the factors you should consider.
I see. So we don't actually approve the county process, you're saying? They just give it to us. We don't approve it. They just.
With respect to the communications plan that the county has to have, they provide that to us. It does say that the Board of Elections shall establish procedures subject to approval of the State Board of Elections to ensure that persons who vote during the early voting period shall not be permitted to vote subsequently in the same election. So there's for that piece, there is that it anticipates that we would give some sort of imprimatur.
But there's no time frame for that to occur?
For that piece, no. The communication plan is due in May.
All right, anything else? So next is public information. John Conklin and Sheriff.
Thank you, Commissioner. The Public Information Office has been very busy since your last board meeting. Hot topics include the changes that the legislature is making to how elections are conducted in New York State, early voting, the June primary, the changes to signature requirements for this petition gathering period, electronic poll books, always campaign finance, cybersecurity, schools as poll sites, and lastly, the public advocate election in New York City yesterday. The unit also participated in the monthly call with the Election Commissioners Association in January. We continue to be part of all the meetings on cybersecurity, the implementation of the contracts with regard to risk assessments and intrusion detection systems and the managed security services for the counties. We processed 104 FOIL requests in January. We continue to participate in the meetings on the Eason lawsuit. We did place an order for voter registration forms, approximately 900,000. About 740,000 of them will be English, and about 154,000 of them will be Spanish. The unit also sent out NCOA files for the counties on February 8th. And I sent out a notice asking each unit to prepare their portion of the annual report and submit it to the PIO. For the website, we posted the amended results for the 2018 general election after the last board meeting. We posted the 2019 political calendar and a revised version that reflected Chapter 17 and 18 that reduced the number of signatures for public offices and county committee positions. We posted the statewide enrollments in accord with requirements for the June primary and to allow for the determination of signature requirements. We posted a notice to filers and a guidance regarding the LLC contributions that Brian mentioned. We also posted the 2019 campaign finance filing calendar. We've updated the various deadline pages for voter registration and absentee ballot applications for the June primary and for the general election for domestic, military, and overseas voters. We posted updates to the running for office page that reflect changes for the Libertarian Party and the SAM Party. We posted the advisory opinion that was adopted at the January meeting. We posted the updated regulation for Part 6214 on new contribution limits. There have been a number of changes in the county commissioner and deputy commissioner ranks. We've updated those postings on the county boards page and the county board roster page. And lastly, we posted the transcripts for the October and December meetings. The January one will be up shortly. For NVRA, since the last meeting, Patrick and Mike have visited Cayuga, Seneca, Ontario, Wayne, Nassau, and Orleans counties for nice voter reviews. All those counties were found to be compliant. The unit would like you to know that they traveled 2,930 miles for those visits. And lastly, we are processing contracts for education, training, and capital funds for the counties. Not every county has money left in those categories, but we mailed out the contracts. So for the commissioners who are listening out there, please sign and return all 4 copies. If you have any questions, please contact Pat Campion or Mike Machete in my unit. I think that's it. Do you have anything you want to add?
No, thank you.
Okay.
So we'll have ITU, William Cross.
Good afternoon, Commissioners. Let's start with projects. Capus Vitus, always at the top of the list. Development continues. Recent activities focus on electronic filing and primarily back office functionality. I wasn't here last month for the meeting, but I know a question was raised about LLC implementation and the change there. We don't feel that's going to be a substantial change. I know that was discussed last month. We've begun implementation of a front-end portal for the system, a more secure portal that not only covers Capus Vitus but also Nice Voter and some future applications where we envision users of these applications will have a central login screen. We'll authenticate them and then go into whatever applications they have rights to, and that will be much more secure than we currently have for Nice Voter, and incorporate multi-factor authentication and some more modern-day security features around that. So we're taking the opportunity to put that in front of Capus Vitus as well. We've begun our next round of outreach for the project work groups. We did an several internal demonstrations of the EFS filing portion of the system, I think Bill referenced earlier. We have a scheduled treasure work group meeting, which will include some of the public entities and good government groups for next week on March 5th. We're also scheduling the demos and outreach for the vendor and the county work groups in April. We're also trying to get a demo scheduled for the board that will primarily focus on some of the public facing public reporting portions. Hopefully, I think we're looking at end of March, April now, if we can. We're also continuing our efforts to fully staff the project, as always. I think that line's always in here. We have identified a new candidate as one of the programming positions and making an offer this week. We've also added one additional contractor to help the data conversion effort. And the schedule, we haven't officially moved the date. We know that it's not accurate, but we are still not that far off it. We are still in 2019, and we're really looking at most likely for at least a portion of it in the July timeframe, hopefully. Maybe still optimistic because we're still trying to fill out a couple of the positions, and based on the budget, it's still, there's contingencies there. For Nice Voter, we're continuing work with the vendor to finish implementation of that project. Everything's in place. We just have to do some final testing, particularly with the disaster recovery and our ability to fail over from our primary data center to our disaster recovery site. We're trying to get that testing scheduled as well. It is looking like it will be later March or early April for that. The move progress, the redevelopment of that is also moving ahead. And as well as our accessibility effort, we worked with PIO and the other BOE units and completed all the work that was required for the December 2018 deadline in the lawsuit. All that work was completed prior to that deadline. We're currently developing projects to meet the requirements of the 2019 deadline. Those are more substantial. We've got a good jump on how we're handling a lot of the website remediation work, and particularly the PDF files that are out there, some of the legacy files. But we also require changes to voter lookup, election night reporting, and some modifications still to the new Capus Fidus system. The portions that were developed early will have to be retrofitted with some accessibility updates. But we're currently planning those out and put a timeline on all of that work for 2019. Security is always top focus as well. In terms of activities, the secure election staff has worked with the county boards and county boards and county IT and several recent cyber incidents in some of the counties. In each case, we've brought down our connections to the statewide system and then worked with the counties and their vendor and the partners on recovery efforts. We've had three most recently. Two of them are back up and running, and we're working as we speak with the last of these. Is Broome County. We're being brought back online today for them. In each of these cases, it's been the Board of Elections hasn't specifically been targeted, but has been affected due to lack of segmentation in the counties. Their systems are mixed in with everyone else's in the counties, so we kind of catch shrapnel in that case in terms of some of the effect on what has happened. But we have, in each of these cases, though, we've discovered that some of the systems that they were running were quite out of date and beyond end of life in some cases. And as a prerequisite to them coming online, we've required them to bring these systems up to date, and they worked with their vendors to do so. In the last case, Broome has actually taken the opportunity to segment elections from the rest of the county, which is a welcome effort. We also continue to work with the counties on several of the other projects. The risk assessment, it's been mentioned a couple times already, but they've now completed approximately 45 site visits. We're working with them to refine and finalize the reporting format for the counties, and the next steps of what we will do in terms of a procurement for helping the counties remediate any of the issues identified by these reports. The intrusion detection systems, the rollout has begun. They've completed the first 7 pilot counties. We enlisted their feedback in the pilot counties, and it was all positive in terms of the benefits providing them, as well as the workflow and working with the vendor to implement them. So we're now proceeding with the remainder. We're also working with the managed security vendor, Sedera, on the initial pilot counties for that project. Unlike the intrusion detection, that one is not mandatory. We're not requiring this capability in each of them. It's more of an a la carte option. However, 30 counties have expressed interest in it. That will be beneficial to them. We're working on several security improvements for our own systems, including enhanced malware detection. I mentioned the multi-factor authentication, some increased logging capability, and as well as upgrading our own internal documentation for policy procedures around information security. And we've also now scheduled a date for our federal Department of Homeland Security risk assessment they'll be performing against our systems. That's scheduled for late July, and I expect we'll probably have several pre-planning meetings with them for that. And we, as well as operations and others, have begun working with the Center of Technology and Government for various projects and initiatives, one of which is analyzing NICE voter data for abnormalities. That project has been defined, and now we're starting some initial meetings on that effort. We've also started some initial discussions with them on researching improvements to the overall elections infrastructure. If we can define it, ultimately the goal might be to define a uniform model for elections infrastructure end-to-end that we can carry into the future, and hopefully deal with some of the segmentation issues or lack thereof that we currently have in the counties. Well, that is interesting.
Somebody's in the petition room.
Is that my cue to get off stage?
Are you finished, Bill?
Pretty much. The only thing I had left was website analytics. As I expected, everything's dropped back to normal post-election levels and patterns for December and January.
Any questions?
No.
Okay, well, thank you. All right, our last report is from the Enforcement Unit, Risa Sugarman, but I see that she is not here. Mr. Quayle, she commenced one proceeding in the last month?
Hearing officer proceeding. Yes, I believe that is correct.
And that's out of the 2,700 referrals that are outstanding?
Yes.
All right. So then we'll move on to old business. The resolution to approve the revised affidavit envelope. Someone want to just briefly explain what the revision is?
Early voting law required the ability of a person to attest in their affidavit that they, I'm going to summarize, erroneously been recorded as voting. So we added that. So if you show up to vote and it says you've already voted, you can vote an affidavit to preserve and it can be reviewed later. But it required a line to be added to the affidavit that they can attest to. The line says, I am enrolled in the political, or excuse me, I have not voted in this election, but the records of the board indicate that I have already voted. As the reason why they were being able to vote at early voting.
Yeah, no, and that record would be a signed poll book. Is that the presumption that someone signed the poll book with my name, but I'm now saying that wasn't me, so you should let me vote?
In some instances, it isn't your name, but it's signed because they have the wrong person signed in the wrong line, but they still won't let you vote in some instances. So both of those are usually the reasons. Or perhaps when they're making their list to get ready for Tuesday on election day, they did voter history wrong in order to make that information that moves from the 80s of early voting to the Tuesday. So either any of those kind of combination of issues could happen, but at the point that they're entitled to vote an affidavit and then investigate.
I'm just trying to understand the situation. So I come in to vote, and this is now, early voting's already taken place, and I show up on election day, and I think my assumption is if I've already voted early voting, my name's not in the book anymore. Is that true? Do you take my name out, or your name is there?
It could be the same book, and it's
So the
already
name's
got a
there,
signature.
it's just my signature place has been filled in.
If it were electronic poll book, it would not,
Have some
you could
indication.
see it, but it couldn't activate to let you sign again because it would normally be grayed out, but you can see that something happened.
And there was just one example that you gave where someone else's name was signed within your signature block. My signature block says Douglas A. Kellner, and the person has signed John Smith in that signature block. It is my view that the inspector should not.
Oh, I agree with you.
Should allow them to vote and find a place where you can sign your own signature. That's not a proper basis for the inspector to ask you to do an affidavit ballot.
But
Fair enough, that's board error, I would
Right.
say.
Well, I agree.
And that shouldn't preclude me.
But that
from
has happened in the past, I'm just
Fair enough.
not that
Well,
I agree with it, but
okay.
I
All right.
agree, we'd want to train to not do that, but.
Fair enough.
I just didn't want the record to suggest that we thought that that was a proper procedure.
Okay.
Okay. So the motion before us is to approve the resolution approving the revised affidavit envelope. Those in favor say aye.
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 So the resolution is adopted. All right, the next is the resolution to amend Regulation 6217.7 on county-to-county voter registration transfers. You want to just give us
Yes.
2 sentences on why we're doing this?
I will try to keep it just that brief. And
The
so
lights will
obviously-
go out.
Yes, sir, and obviously available for any questions. This amendment to 6217.7 is designed to effectuate Chapter 3 of the laws of 2019 that provided for statewide transferability of voter registrations. It and the, for your reference, draft guidance document to counties attached to it is designed to essentially pick up what is presently happening as an intra-county process and make it able to be executed across county lines. That is its purpose. It would be adopted as an emergency regulation, and at the same time, we would publish it for public comment for a permanent adoption, because the statute requires that the process be in place by March 25th. It was a 60-day time frame for implementation.
Any questions?
Yeah, just as a short, so if I move from one county to another, the old county is somehow notified that I've moved, I presume. There's a mail check or something has happened that the county that I moved from has been notified that I've moved to a new address, and I assume they've also been told where I've moved.
Yes.
And so they would then send a notice to the county where I've moved that you have a new voter in your county?
In many instances, Commissioner, yes. And in some instances, the notification initially goes to the new county. So they already have that information. The Department of Motor Vehicles sends address changes to the new county already. But in the instances of mail checks, returned mail, and national change of address, those notices would be received by the from county in this parlance, which would then provide that information to the to county to process the transfer.
So right now, if I go into DMV and I update my record and say I've moved from Schenectady to Albany, DMV will notify Albany that you have a new voter. This person moved from Schenectady to, and will they also notify Schenectady that, hey, you've lost a voter?
No.
They just notify the new.
Yes.
Nice photo will do it. So if, in your example, Albany received the notice, Albany, current now, would be able to put you on the computer rolls in Albany County. Nice voter will send the message back to Schenectady that there's the traditional group management that we already have built into Nice voter will happen. Schenectady will get that notice.
That's done through Nice Voter, DMV
Yes.
doesn't do it.
In the instance where a county receives a notice that, mail check or NCOA, this individual has now moved to a new county, they would do their confirmation process so that in their existing list management now, communicate to the address in the home county, and that's to make sure it's not wrong, and give the voter the postage-free ability to either confirm, yes, I did move, or no, I didn't, so that it can be corrected. But then that board will also have to, once they take that action in their county, would have to provide notice to the county that there's a change of address, and here's the information that's necessary for you to
Start the registration process.
take action.
Now, are there time frames for these notifications to occur?
The statute provides the traditional 21, 25 days, depending which notices we're sending out in order to communicate with the voter that, the process to form. So in one instance, it would be an acknowledgement or the confirmation. Those are already built into the statute. They did not change the notification process with the law. So those are the traditional, the ones that have been in there since NVRA passed in the 90s.
So all this regulation does, it doesn't change the procedures other than to apply them across the state as opposed to just within the county.
It kind of cleans up the old language that was if they move within your county. Now it speaks to if you move within the state, and then we try to accommodate the what-ifs that you described.
Any other questions? So we'll call for a vote on the resolution. Those in favor say aye.
Aye.
Opposed?
Aye.
So the amendment to Regulation 62.17.7 is adopted. All right, the next is the amendment to Regulation 62.17.9 regarding pre-registration for 16-year-olds, also to implement on an emergency basis the statute recently adopted.
Actually, Commissioner, this one would be on a regular course, because our friends in the legislature were kind enough on this one to make an effective date of January 1, 2020. We are actually, this was so easy to do, we could not help ourselves, but to recommend that we do it forthwith, even though it would not actually be applicable until January 1, 2020. We excited our friends in the Rural Regulatory Review Unit when we asked them how we adopt something in February that doesn't take effect until next January, and they were very impressed with us.
All right, well, thank you, and I stand corrected then. Is there any other discussion? All right, those in favor say aye.
Aye.
Opposed? All right, the resolution is unanimously adopted. All right, next is the draft opinion on candidate liability. Commissioner Kasinsky, do you want to summarize it, or do you want to have staff summarize it?
I can speak to it if you'd like. This is an opinion related to the legal liability of candidates vis-a-vis the filing requirements related to their authorized candidate committees. This really comes up, I think, because of what I consider to be really a failure of the hearing process that's occurring in this state since we changed the process a few years ago, where there's a administrative hearing regarding failures to file. And what's happened, and we've reviewed it, is that over the last 4 years there have been 21 hearing officer processes related to failures to file. The problem is that within the context of those hearings, while there's a complaint and allegations made by the counsel, there is not the defense that was anticipated being raised by the candidate and or their committee to the allegations made in the hearing or in the counsel's complaint. So we're not getting the give and take that would normally occur in a hearing process situation or in a court situation. And this issue is a legal issue of whether or not, when a candidate basically turns over the obligation for filing to their authorized committee, if that committee then fails to make the requisite filings, whether the candidate remains legally liable for their failure to do so. The opinion analyzes that under the law, whether or not that liability still attaches to the candidate, and the ultimate conclusion is no, that is in fact the incentive the candidate has for turning over that obligation to the committee, is that now the committee has assumed that obligation. It's specifically the treasurer of the committee, as the person who signs the documents that are submitted here, has that legal obligation. And if there's a failure to file, that the hearing and or court proceedings that would follow would then be against the treasurer, absent some extenuating factual circumstances that would somehow incorporate the candidate or some other person, some other actor in that process. But the assertion that was made in the context of the hearings was that there were two obligations that the candidate had related to their filings. First, they had to file what's called I believe it's a CF-16 is the number of the form we have, which is the candidate saying to us, I'm not going to make any filings, my committee's going to do it on my behalf. But then there was a second obligation that was being placed on them, that if the committee didn't make the filings, the candidate still had the obligation to file, and if those filings were made, they were still being sued and held legally liable. It's my belief that that's a misreading of the law. I think this opinion goes into why that's a misreading of the law. I also think it goes to the public policy behind the whole process of having candidates turn over their financial obligations to a committee, that separates the candidate from their financial fundraising mechanism. I think that is something that we should be furthering by saying that the candidate should turn over that obligation, should remove themselves in large part from that obligation so that it's the committee that's doing the fundraising, and that in essence separates the candidate. We see that certainly in the judicial area, where by regulation the judiciary is prohibited from engaging in any campaign finance obligations or endeavors that their committee may take on. This, I think, while it doesn't go that far, says that the candidate is separated from their committee, is not tied into it anymore. Otherwise, there would be no incentive for a candidate to turn over that obligation. In fact, there would be every incentive not to turn it over, because while I'd be turning over the obligation, I would retain the legal liability of the committee. So, why would I turn over the obligation when I retain the liability? That wouldn't make any sense. I think we should be encouraging candidates to turn that over, and I think this opinion goes a long ways towards doing that.
I agree with everything that you've said in your comments. We received yesterday a 9-page memorandum from the Chief Enforcement Counsel commenting on the draft advisory opinion. And I want to indicate, I spent many hours, both yesterday and this morning, studying the Enforcement Counsel's memorandum. And I'm a little bit disappointed that neither she nor anyone else in the enforcement unit chose to attend the meeting so that we could discuss some of those comments, because I had a few questions on comments that are contained in the memorandum that I think either beg the question or seem to be factually unsupported, and include interpretations that I think are a far stretch from what is intended by the statute. But furthering Commissioner Kasinsky's comments, that I read 14-104 of the election law the way he does, and the way that the board had practiced for as long as I was aware of, that once a candidate filed the committee authorization form, then the filing obligations switched from the candidate to the committee. Now, there are points that are made in the Enforcement Counsel's memorandum that I think are acknowledged at the end of our report. is that just because a candidate files an authorization for a committee does not immunize the candidate from other conceivable campaign finance obligations or violations. And the last sentence of the opinion acknowledges that the opinion is directed only to the authorized treasurer's failure to file a required disclosure report. Obviously, if the candidate has received funds personally and has not deposited them within the committee, well, then the candidate still has the obligation to report. If the candidate aids and abets a fraud on the part of the treasurer with respect to filing, or indeed if the candidate solicits the treasurer not to file, well, those are obligations that are not covered by our opinion, and our opinion is not intended to foreclose prosecution or penalties with respect to those exceptional types of conduct. My response to the Enforcement Council with respect to her memorandum is, to the extent that she thinks that advisory opinions are warranted with respect to any of that exceptional conduct, I, for one, would be willing to consider them, and that the enforcement unit is certainly welcome to submit their suggestions in that regard.
Those are patently obvious, I would feel. So, you know, it's like, don't go through a red light, you go through a red light, that's wrong, period, in the story. It's not really that questionable, you know, especially the examples that you utilized. So my thing, our opinion is right on, and I don't think it needs any further explanations or illustrations.
I agree.
Yeah, I would just comment that I did read the Enforcement Council's comments as well. I think that the opinion as written should be read as it's relatively narrow. It's not intended to cover every situation where a campaign finance violation might occur. It's a relatively narrow holding that in the failure to file context, there is no what I would call strict liability attaching to the candidate. It attaches to the treasurer. I think that, you know, her analysis goes far afield from that. I think a lot of her analysis analyzes issues that are tangential but not on point. So, you know, while I take her comments, it doesn't affect my opinion that the opinion as written is correct and you know, that we should adopt it. So
I agree with that.
I would just point out that this will be a formal opinion.
Let Commissioner Spano speak first. Go, Commissioner Spano.
No, I was just from a practical standpoint, you know, looking back on how these operate in reality. You know, you get a high slum campaign with lots of money coming in. You hire someone, I'm sure Greg can relate to this, hire someone to take a look at these things before they're filed. Someone goes over them, you call people to make sure that the candidate can't be involved in all that process. And to hold them responsible at that particular point, you ask about it, you take some due diligence, and is everything okay? But you can't be responsible for every single thing. That's why you have a treasurer. And usually you get someone who's really good at numbers and doing this kind of work, even a CPA.
Normally, as far as the candidate's involvement is concerned, you know, I can tell you straight out that when you have somebody that for you, great relief, because you have too many other things to do. We had a committee that actually cleared the checks to make sure there weren't any conflicts of interest, and then beyond that, you know, as a candidate, I would say, we're going on TV. Can we afford it? That's about it. It's gonna cost X amount of dollars, whatever, and that's the extent of any candidate's position. The bottom line is, that's why you do this, and that's why you have a treasurer.
That's correct.
To involve the candidate, I think it would be ludicrous. And it's not written in the law.
I would just merely point out that this is a formal opinion. It doesn't relate to 14130, which would be the advisory opinion, so.
I'm sorry if I misspoke. Okay, so those in favor of adopting the formal opinion, say aye.
Aye.
Opposed? All right, so it's adopted unanimously. I had one issue I wanted to add to the agenda to discuss very briefly, which is the issue and the litigation that started in this last week between the New York City Board of Elections and the mayor regarding interpreters at New York City poll sites. My own view is that both sides are wrong in how they're trying to address this. That the state constitution is pretty clear that poll sites have to be operated in a bipartisan manner, and that our laws implementing that constitutional provision put the New York City Board and the county boards of elections in charge of that. On the other hand, I think the mayor is trying to accomplish a laudable goal in trying to increase the number of interpreters that are available and providing the funding for it, and that the New York City Board may be excessively obstinate in accepting that additional funding and trying to address the problem that that the mayor is trying to address. So to that end, I would suggest that our operations unit contact the parties to provide us with information on the litigation, and to see if the state board can provide a productive role in trying to mediate a resolution of the dispute. And of course, we could then explore further if the mediation is unsuccessful because neither side is, or one side is unwilling to accept our views on how to proceed, then we could explore whether to intervene in the litigation.
That's fine. I agree that, you know, I'm troubled too by the mayor's insertion of himself into the poll sites. I think that this Constitution, not to mention, again, a public policy argument that the bipartisan Board of Elections is in charge of poll sites for good reason, as they are in charge of election operations in general, and having the mayor insert himself into a poll site like this, I think is troubling. So I would agree that we should look into this and see what we can do. If there's some way of resolving the issue, that's great. But I do have a threshold problem with that. I don't know where the court case is vis-a-vis the authority of the mayor to insert people into poll sites, but I think that's a very troubling precedent that could, you know, lead to any number of other insertions of a mayor, a county executive, any number of political persons into our poll sites, which I think is a very bad precedent to set here in New York State. So that's an issue, but I also...
And I would just say that, but the unwillingness to provide for additional interpreters when the local government is prepared to pay for it invites that kind of intervention, and that's why I think we could provide a productive role in trying to get the parties to resolve the dispute.
Well, if we can help work something out, that'd be good. So if we can look into that, that'd be good, and see what's what.
Commissioner Spano, do you agree?
I agree.
All right, so we all agree to ask the operations unit to follow up on that.
You guys wanted another job, didn't you?
Yes, thank you.
My schedule is clear.
Your nights are no longer
I'm not aware of any need for an executive session.
Nope.
And I think we've already scheduled our next meeting.
We have March 19th and April 29th.
So if there's no further business, we'll accept a motion to
We
adjourn.
adjourn.
Second?
All right, we're adjourned.
First is-